Hey everyone, it's Shaun Southworth, your federal employment attorney, back with an update on the lawsuit seeking to block the Trump administration's fork in the road, deferred resignation program. The block is only temporary, and while it's a sign of a win, it might not continue. I've spent the past few days reviewing the union's complaint, the government's response, and the arguments on both sides. Here's what's going on and what to watch for at Monday's hearing. Jurisdiction and standing. The unions argue they have standing because they've had to divert significant resources to advise their members, and they risk losing dues if employees resign. The government says that's not a valid harm under constitutional law, and the Civil Service Reform Act likely requires these disputes to go through specialized administrative channels, not in a federal district court. So I think the first question for the judge is, does the court even have the power to hear this case? Anti-Deficiency Act concern. Unions claim OPM can't guarantee pay and benefits through September if Congress hasn't appropriated funds beyond mid-March. The government responds that employees remain on the payroll just like normal, so no separate appropriation is needed. The judge may press on the government on whether the plan violates spending laws or is simply a novel approach to voluntary separation. Likelihood of success and irreparable harm. For a temporary block to continue, the unions must show that they're likely to win the ultimate lawsuit and will suffer immediate harm if the program goes forward. The government counters there's no real harm from a purely voluntary program. My thoughts, will the judge focus, I expect, thorough questions on whether the union should bring these claims in a different forum and whether there's jurisdiction to hear the case. The timing factor, expect the court could consider how rushed or coercive the plan might be. The judge thinks employees face serious immediate pressure. A temporary pause may be kept in place. It's also possible the program could stand while the case proceeds. So for Monday's hearing, the court could extend, modify, or lift the current stop on the plan. We'll get a clearer sense of whether the judge sees a solid legal basis for this challenge or believes the claims belong elsewhere. It's an unprecedented situation, so it's all very difficult to tell. Next steps for you, if you're affected, keep an eye on Monday's hearing outcome. Whether you're an employee weighing your options or union rep advising your members, there's likely more clarity coming soon. Regardless of the outcome on this, though, I think at a time where a lot is happening, the union is trying to take a position and advance workplace rights on a more collective basis. And so in my mind, much kudos to them for doing this. If you, regardless of the outcome of the case, appreciate them collectively fighting for the workforce and you could be a dues paying member, perhaps, you want to reward them and suggest by joining them to help them at least get this out to the public. In terms of how the judge is going to rule, these cases are heavy lifts, but I think this is a pretty unprecedented situation. Please follow me across all social media for more information. We do want to get information out. We are also working, we've been a little delayed on launching a website that will provide daily newsletters to people, training or information for people on their basic federal employee rights, and then group coaching sessions with me where at least once a week I will take live questions. If you're interested in that, check out the link tree to get information about that when it launches. Otherwise, please follow me across all social media. Appreciate everybody and hope everybody has a great day.